Hello. Like we talked about last week, there are a lot of legal rules in terms of who can access patient-specific health information. Healthcare providers are required by law to keep patient information confidential and also to allow patients and third parties, such as insurance companies, to access this information. So these laws are specific to the information that is deemed confidential, such as clinical data that the doctor learns like during the course of the patient's treatment. Most people that work in the medical field don't know the ins and outs of these legal rules. And that's where health information professionals come in, right? To have this complete understanding of all of these things, okay? At this current time, the question of who owns the health information is kind of in transition. But traditionally, as we've learned already, the law has focused on who owns the medium. The paper record, right? And we know that this is the doctor or the hospital, the healthcare provider, right? The patient does not own the record and technically has no right to it. And it used to be the doctor got to make the decision on if the patient could even have access to their own record. The more modern view is that the doctor still owns the medium that the health record is stored on, but the patient has the right to access it. And this is recognized by the HIPAA privacy rule. So the future view of who owns the health information is that the doctor holds the health information in trust for the patient, meaning they create and add information and protect it, but only for the benefit of the patient. But the law hasn't really caught up to this trend, so we'll see what ends up happening in the coming years. Now, while the law hasn't changed to meet this future view, a lot of governments or commercial entities have started using these health record banks, which is a repository of personal health records. A repository is like a central file storage location. So these banks serve as the custodian. They just house the records, and the data is still fully accessible to the patient. Okay. So even though the question of who owns the health information is still in the air, everyone still acknowledges that the medium, so the paper or the electronic chart, is owned by the provider, with the patient having the right to access it. And again, this was all established by the HIPAA privacy rule on the federal level and by statutes, licensing regulations, and judicial decisions on the state level. All right. We've already talked about all of the uses of health records, the main one being to support the patient's care, but doctors can also use them to help with fundraising and marketing. But if that's the case, the doctor is required to notify their patient with a notice of privacy practices, okay? This was established by the HIPAA privacy rule as well. And it just lets the patient know that they have the right to request a copy of their record, request amendments to it, or confidential communications. They can ask for limitations on use and what is shared. So meaning like they can request that, certain information is not shared to XYZ. They can get a list of those with whom information has been shared, a copy of the privacy notice. They can choose someone to act for them, and they can file a complaint. Okay, so this notice of goodness gracious, notification of patients' rights, sorry about that, gives you the power to say, no, I don't want you to use my information in this way or that way or whatever, okay? All right, on top of the notification or the notice of privacy practices, the doctor can also try to get a general consent from the patient to use or disclose their information in order to carry out treatment or get paid. So this type of consent is called a consent to the use and disclosure of health information or treatment for treatment, payment, or healthcare operations. And the privacy rule also says the patient has the right to say no to this as well. So here's what has to be on the form. Let's see. It has to be in plain language, so like easily understandable. It has to explain that information can be used and disclosed for treatment, payment, and operations. Reference the notice and the right for you as the patient to look at it. It can state that the notice, or it should state the notice can change, and that there's a right to obtain a revised notice, inform you of the right to restrict use and disclosure, and inform the health care provider's option to not agree with restrictions, and you have to sign and date it. Okay. Before 2009, the privacy rule actually allowed doctors to not honor the patient's decision to not give consent to have their information disclosed. That was not very long ago. That's just wild to think about that with how it is today. So a doctor could say, I won't treat you unless you disclose this information, or an insurance company could say, we'll not cover you or let you be enrolled unless you disclose this information. But the American Recovery and Reinvestment Act in 2009, or ARA, changed that. So the doctors and insurance plans had to comply with the requested restriction if a patient requests that. The Secretary of Health and Human Services issued some regulations on how to navigate this issue as well. Some states have adopted laws that are even more strict than HIPAA that go over confidentiality and authorizations and all of that. For example, Montana and Washington have adopted the Uniform Healthcare Information Act, I think, which is very specific on how they're supposed to notify the patient of their confidentiality practices. Like it lists it out very specifically. But because there are so many federal and state laws about the same thing, the health information manager has to figure out how to reconcile all of these requirements to make sure they're meeting all of them, right? The first step in this reconciliation process is to address preemption. So, do the federal laws take precedence over the state law? And if so, they have to be followed. The second step is just being compliant with both federal and state laws if they are more stringent. Okay, so whichever law is more stringent or strict is the one you have to follow. That's the general rule. If you're ever unsure, follow that rule. Now, because there are so many complex laws and regulations regarding access to health information by the patient or insurance companies, health information professionals have to have a good understanding of the general principle of disclosure of information and the differences are between access by the patient and access by insurance companies or third parties. Okay, so what are these general principles of disclosure of information? The general ownership rule is what we talked about earlier. The doctor owns the health record and the patient has the right to access it. So from that flows two other principles. The first is that the record remains within the provider's control and can only be removed by a court order or a subpoena. The second is that the provider cannot disclose or withhold a health information at will. The patient has to give express consent. Okay. The HIPAA privacy rule has a list of core elements that have to be on a valid authorization. All the things that you see listed here. I'm not going to read it out to you. You can read that if you want to pause the video, by all means. And really, it's all things that you would expect, right? Now, a release form would be considered invalid if it has any of the following defects. Okay, so you will have a release of information assignment this week, so pay attention to these things. So if the expiration date or event has passed, if it's not complete, if it's known that the authorization was revoked or that it lacks a core element, if it contains a compound authorization violation, and if material information in the form is known to be false. Okay, the principle of the minimum necessary standard, which is under HIPAA and ARA, requires that the doctor has to make reasonable efforts to, a lot of reading from the slide here, sorry guys, limit patient-specific health information to a limited data set, minimum needed to accomplish purpose of use, identify who needs access to meet duties, implement policies and procedures, and then to develop criteria to limit the items disclosed. Okay, and then here we go. Who can grant the authority to release PHI? This is governed by state law, and it can be a patient who's a competent adult or an emancipated minor, the legal guardian or parent of a minor child, and the executor or administrator of the estate if a patient dies. And then the method of disclosure has to also be addressed. Professional guidelines or institutional policy will usually list out what the appropriate methods are. It can be by mail, electronic transmittal, fax, or telephone. Okay. The last thing that has to be included is a redisclosure notice. This is mandated by state law, and it says that the information can only be used for the stated purpose, that the recipient can't give the information to anyone else without the patient's authorization, and that the information should be destroyed after it's used. If the information relates to alcohol or drug abuse treatment, then federal law also mandates this redisclosure notice. Okay, all the other information is state law, but for alcohol or drug abuse, it's actually a federal law. Okay, so we've already talked about this, but this right to access their information has only recently been made into law by the HIPAA privacy rule. As you all know, this gives you access to get a copy of your PHI in whatever format it's in for as long as it's maintained. And again, the American Recovery and Reinvestment Act is what addresses electronic health records. Not all states have regulations or statutes addressing this legal right of patient access. So while HIPAA establishes the floor of patient rights, it doesn't have a cap or a limit or max, right? States are able to give even further rights past what HIPAA requires. Patients that are treated in federally operated facilities like Veterans Administration hospitals or Indian Health Service clinics typically have more rights to access their own health information or to get a copy of it or make changes. This is all under the Federal Privacy Act, which only covers, facilities operated by the federal government. Now, although patients have gotten more and more rights to access their health information, it's not an absolute right, meaning under certain circumstances, the doctor may be justified with withholding access from the patient if they think it would have a detrimental effect on them. This is usually only happens in the context of mental health treatment. And it's also kind of like a gray area. The HIPAA privacy rule also gives a time frame for how soon the provider has to respond to a request. And then something that is more recent is the use of personal health records, which is a collection of patients' important health information that can be pulled from different doctors or sources and is managed by the patient. And obviously they have to address like security and privacy, and notify patients if there's ever a breach. If any of you go to a doctor's office that uses like the MyChart app or any kind of like patient portal where you can log in and look at your lab reports, or your doctor's visit notes, it's really cool to be able to see all of your information, and then you can do it for your kids as well. But this is a good idea to try to keep a personal health record, to have all of your information in one place. I think it's a really good idea, something that I do. Okay, for health information to be released to a third party, so like an insurance company, there has to be a valid authorization if the third party is the patient's attorney or insurance company, a federal, state, or local government agency, or a member of a competent adult patient's family. Okay. In certain instances, the third party may be able to access the information without patient authorization, such as for workers' compensation, if it's a parent of an emancipated minor, a person with medical durable power of attorney, meaning they're able to make medical decisions for the patient, a provider with need to know in order to perform a job, and then surveyors with accrediting or licensing agencies. So that's when a licensing or accrediting agency like Joint Commission comes in to audit the records. They can access them. Okay, ARA prohibits the selling of patient health information from a doctor to a third party because, again, a written authorization is required, with the exception of public health activities, research activities, patient treatment or payment, sale, merger, consolidation. So like if two facilities join, or if a facility is sold, and then for business associates pursuant to a written agreement. All right. When a facility gets a request for a release of information, they have to pay for copying, like making copies of the information or putting it on a disk or whatever medium that it's going to be given in. And there's also the cost of the employee's time and their labor. So because of this, state law says the healthcare provider can charge a reasonable fee. HIPAA and ARA also talk about reasonable costs for all of this, but as we talked about at the beginning of this semester, there's been a really big push to limit what you can charge patients, since they do have this right to access their information. It shouldn't cost them this crazy amount of money to get it. But jot this down somewhere. So in the state of Louisiana, the reasonable copying charge is not to exceed $1 per page for the first 25 pages, and then 50 cents per page for pages 26 to 350 pages, and then 25 cents for every page after that. And then you can also charge a handling charge that cannot exceed $25, and actual postage. So that's for paper records. If the treatment record exists in a digital format, then the charges for providing the digital copy, so like on a disk or a flash drive, cannot exceed $100 plus all of the postage charges actually incurred. Because, the hospital does need to recoup these costs, right? But they just can't charge hundreds and hundreds of dollars, because that would make it hard for a patient to access their information if they're having to pay these exorbitant amounts. Okay, the reason we've been able to have all of these rapid advancements in healthcare is because of medical research, right? These studies have measured the impact, effectiveness, costs, among other things, of different like medications, treatment methods, occupational hazards. And so this has led to improved quality or effectiveness of care, improved outcome, new medications being created, and treatment and prevention of illness and disease. Okay, so medical research is needed and great, right? These medical research studies here involve the study of the test subjects or individuals as well as the study of health records. So the studies are done concurrently as opposed to looking back after the person is no longer in the study. As we talked about a few chapters ago, there are a ton of regulations on the federal level that have to do with test subjects. It wasn't always like this, though. During the middle and end of the 20th century, so like 40 to 75 years ago, they were performing medical experiments on people with no regard to the person's safety. The most notable example would be the Nazi medical experiments, or the U.S. public health studies on African American men having to do with syphilis. And then the third is the injecting of dangerous substances into vulnerable people. But there are a lot of examples of this, unfortunately. When people started finding out about these things, there was outrage, and they responded with legal trials to punish the people that conducted these experiments, like the Nuremberg trials. And also, thankfully, it led to the creation of these guidelines that physicians have to use when they're conducting research studies. In the 1970s, Congress passed the National Research Act, which authorized some regulations and developed a commission to create some basic ethical principles for human research studies. So this commission published the Belmont Report, and it asserted these three main principles: respect for people, and they should have informed consent and privacy, beneficence, so balance the risks with the benefits, justice, select subjects equitably and avoid exploitation. So like a wide array of people, not just one group of people. The Belmont Report also provides the ethical basis for the federal regulations that govern any research involving human test subjects. Okay. The regulations require that all research involving human subjects must be reviewed by an institutional review board, that all patients have to give informed consent, and that the institution must ensure that it will comply with all of the federal regulations. These regulations are administered by the Office for Human Research Protections, which is a part of DHHS. Okay, these researchers have to balance the need to keep patient information confidential, and the fact that in order to successfully do a research study, they have to be able to access the health information of their subjects, right? So to address that balance, there were federal regulations created. DHHS supervises investigators that receive any federal funding for their research, and the FDA supervises clinical trials of pharmaceuticals and medical devices. The regulations also require that an institutional review board has to approve the research protocol before they can use a human test subject. Okay, the institutional review board is chosen by the institution, and their role is to safeguard the rights and welfare of the subjects, review, approve, and monitor medical research to make sure the patients are going to be kept safe, that the test is reasonably done. The investigator must submit plans and informed consent forms for approval, and the Institutional Review Board determines whether regulatory standards are met and if the study is ethically sound. Okay. All right, so the institutional review boards then use HIPAA regulations, the privacy rule in particular, to determine whether PHI can be used, whether patients have authorized use, and whether a waiver of authorization is warranted. Also offers two alternatives to researchers who are interested in collecting or using data about human subjects but don't want to go through the institutional review board review. The first alternative is referred to as the HIPAA safe harbor provision, and it's the use of de-identified data. So all the patient identifying information is removed, like name, any PHI. The second alternative lets researchers use a limited data set, which has all direct identifiers removed, like the city, state, zip code, dates of service. It has all the direct identifiers removed, but the city, state, zip code, dates of service, date of birth, date of death can all remain. Okay. In order to use this limited data set, researchers are required by HIPAA to use agreements with the entity that provides the limited data set. So the direct identifiers that have to be removed include name, address, phone or fax number, email, social security, anything to do with their insurance plan, any biometric identifiers like photographs or images. Okay. And the health information manager should always double check that all requests from investigators have been approved by the Institutional Review Board, that the requests are treated with great care, that any that have not been approved are not granted, right? They don't give out that information. That a written statement is included prohibiting redisclosure without consent, and that proper data policies, standards, and procedures are applied. Okay, moving on to if a business associate requests release of information. HIPAA, ARA, and the HEIT HIPAA Omnibus Final Rule regulate this scenario. So a business associate is someone who performs or helps perform a function, or is actively involving the use or disclosure of PHI on behalf of a covered entity. So this is not an employee of the doctor. This would be like a vendor that does billing or quality assurance or shredding or something like non-clinical related. One of the HIPAA privacy rules for this requires that the doctor and the business associate have a written agreement, and the agreement has to specify these things here: permitted uses and disclosures and prohibited uses and disclosures. So what can the information, what can be used and what can't. Assurances that safeguards are in place to prevent unauthorized use or disclosure. That DHHS is authorized to determine business associate compliance, and that subcontractors and agents are bound by agreement and are also subject to the provisions of the privacy rule. Okay. Under ARA requirements, the doctor has a duty to make sure the business associate is compliant with the terms of the agreement. And if they're not, they can tell them, like, look, you have to conform to these HIPAA regulations or else we'll cancel the agreement. If the doctor's not monitoring these practices, it's a violation of both HIPAA and ARA. ARA also requires the business associate to respond to any non-compliance by the doctor. So same thing as before, the business associate can hold the doctor responsible for following HIPAA regulations as well, or they can cancel the agreement. Also, the business associate has to notify the doctor of any breach of confidentiality, of course. There are also instances where access to patient-specific health information is necessary to safeguard public health. State laws require reporting threats to public health, such as any communicable diseases, child abuse, injuries caused by deadly weapons, fetal death, and cancer. And HIPAA allows mandatory disclosures without patient authorization in these situations here. Emergencies concerning public health, health oversight, instances concerning victims of abuse, adverse events, law enforcement use in identifying or apprehending an escapee or violent criminal, and judicial or administrative proceedings via a court order. Okay, in pretty much every state, adoption records are considered confidential, and they're usually only disclosed for legal procedures, right? There are two competing interests, though. The first is the interest of the biological parents in placing the child for adoption. Usually they have the promise of confidentiality. The second is the interest of the adoptee for genetic information, or if they're curious about their birth parents. So this has become a bigger thing lately because more and more people that have been adopted have tried to find out information about their birth parents. But the courts have tried to limit it because they're worried that less people will be willing to put their children up for adoption because they're worried that later on down the road, this child will try to come find them. So it's kind of a tricky situation, but most states do require a court order, and the adoptee has to establish good cause for why they want to know who their birth parents are. For example, like if they were to need the genetic information to figure out a medical condition or a psychological trauma or something like that. The health information professional needs to be very familiar with their state laws about this so that when they do get a request by an adoptee, they know how to handle it. Okay, and last topic for today. Not all requests for information are legitimate. There are people out there who try to get patient-specific information with ill intent, such as identity theft, which is using someone else's identity with the intent of doing something unlawful. This could be trying to find someone's address or social security number. So health information professionals have to be proactive and use these preventative measures so that this doesn't happen. So things like using technology to safeguard PHI, doing background checks for employees and associates, the redaction of personal information, policies and procedures for record retention, record destruction and disposal, and then access to PHI based on need to know. So these preventative measures are not only smart, they're also required by federal regulations. The Federal Trade Commission, or FTC, has issued these red flag rules that most healthcare organizations have to comply with, which are to identify relevant red flags. So different like alerts, notifications, warnings, if there is some sort of suspicious activity. Prevent and mitigate through responses to red flags. Like what do you do when you get one? Update the program periodically and administer program training and involve like the leadership. Okay. But even with all of these measures in place, identity theft can still happen. So the health information professional has to have some sort of strategy in place to detect and respond to these sort of, unlawful accesses. All right, and that is all I have for you today. Let me know if you have any questions, and I'll see y'all next time.